everyone and welcome back to another video. So late last year there was a major change in employment law in the UK, and if you're an employer it definitely affects you. And that's what we're going to be talking about today. So as of the 26th of October 2024, under the Worker Protection Amendment of Equality Act 2010, employers are now legally required to take reasonable steps to prevent sexual harassment in the workplace. If you haven't seen me before, hi, my name is Amy. You might recognise me from my social media platforms. I am also an independent HR consultant. For a full list of my services, please check out the description. So in this video, I'm going to explain the main consequences if you fail to follow this new legal obligation, how this is potentially changing under Labour's new proposals from the Employment Rights Bill, and what employers should have done already, but if you haven't, what you should be doing now. So handling sexual harassment is no longer just about reacting after the complaints happened. Employers now have a proactive legal duty, and failure to comply can mean financial penalties, legal action and reputational damage. Before this change, the law focused on protecting victims after harassment had occurred, but now, under the new Act, employers must actively prevent it. So what happens if you don't? You can face enforcement action from the Equality and Human Rights Commission, the EHRC, even if no harassment has happened yet. They do also have the power to fine. And if an incident does happen, there's a big new consequence. So if a worker brings a sexual harassment claim and the tribunal finds that you failed to take reasonable steps to prevent it, their compensation award can increase by up to 25% across all successful harassment claims that they brought, not just the sexual harassment one. Just really briefly, what is sexual harassment? So according to the Equality Act 2010, sexual harassment is any unwanted conduct of a sexual nature that either violates someone's dignity or creates an intimidating, hostile, degrading, humiliating or offensive environment. This includes inappropriate comments, touching, jokes, gestures or any conduct that crosses boundaries, even from third parties like clients and customers. So what should employers do? I'm going to cover the top 5 main things that employers should do based on the EHRC guidance, which was published when this law came into effect. However, on my website, you will find my Prevention of Sexual Harassment pack. That took me weeks to put together, so you can save yourself lots of time if you decide to purchase that. Included in there is a detailed and easy to follow employer guide, what employers should be considering now. I've gone through the entire EHRC guidance and I've composed a list of what to consider. There's a PowerPoint training guide for delivering training to employees with notes so that you know what to say on each slide, delivering the training as and when required because it does need to be repeated. There's an anti-harassment policy which contains the requirements as set out by the EHRC guidance, a risk assessment template and draft action plan templates with examples of risks, and an anonymous employee harassment reporting survey. Like I said, I'll put the link to that in the description below. The top 5 things that employers should be doing according to the EHRC guidance. Number 1, the anti-harassment policy. Make sure you have one, make sure it's sufficient. Your other policies are not likely to suffice. There is strict guidance for what should be included in this policy, including clear examples of unacceptable behaviour, third-party harassment, the reporting procedure, how malicious complaints are handled, the consequences for violating the policy. That's not an exhaustive list, I've just covered a few of them. The next one is training. So the EHRC have said that training is absolutely mandatory. Anti-harassment and sexual harassment training for all staff, including management. This should be repeated regularly. The suggestion is every 6 to 12 months or as and when required. For example, if someone new starts or when an incident happens. Training needs to include certain things. One example is how to identify harassment, including the different types, such as bystander intervention, third party, conflict management, the reporting procedures, ensuring staff understand the consequences of failing to comply. In the sexual harassment pack that I mentioned, I do have the PowerPoint training document that you can use to deliver the training, as and when required, complete with the presenter notes that you know exactly what to say. Next, they put forward risk assessments, and the EHRC have stated that without risk assessments, an employer is highly unlikely to pass the requirements of preventing sexual harassment in the workplace. And included in the pack are draft risk assessment templates and action plans and examples of risks to help you complete them. A couple of examples from the EHRC guidance in terms of risk assessments is that employers should implement, document and retain risk assessments, emphasising roles and areas with the increased likelihood of harassment, including third-party harassment. They should use the risk assessment to implement preventative measures such as additional training, physical changes to work environment to mitigate risk. One of the next points is to build a safe reporting culture. So employers need to communicate to employees through training and their policies how to report incidents, provide anonymous reporting options, and they should also be issuing anonymous surveys to employees to assess if sexual harassment has occurred previously or currently. Again, that's in my pack, a draft anonymous survey for you to issue to your employees. The next one is in terms of criminal behaviour. So employers should have provisions on how to handle criminal behaviour, because harassment in the workplace can also be a criminal matter. Employees should be notified that information may be shared with the police in relevant situations, and also what to do if the employee doesn't want you to share that. The last one I'm going to mention in this video is support, monitoring and feedback. The EHRC have also focused heavily on having provisions for support for employees, how the employer will monitor incidents, how they'll obtain feedback on the effectiveness of the measures that they've put in place. Labour are planning to change things. What is changing? Labour have planned to change the requirement to put reasonable measures in place to all reasonable measures, which is considerably more severe. However, it's been discussed that in all likelihood, the guidance from the EHRC on the current requirements is likely to be sufficient for the new requirements if they come in also. The biggest factor is going to be the proposal for third-party harassment claims to be eligible for compensation at tribunal. Currently, there is no route for an employee to claim compensation for third-party harassment at tribunal, and that is planned to change. My pack does cover third-party harassment and what you should be doing to put measures in place to prevent that. We are still waiting to see what Labour bring in terms of third-party harassment prevention, so that might change in the future. Like I said, that's just a few parts of the guidance that the EHRC has published. If you want my full breakdown of it, along with the anti-harassment draft policy, the draft risk assessment templates, the PowerPoint training document, the anonymous survey, you can get that over on my website. The link is in the description below. But this is not something that is optional. This is a legal requirement. And if you are reported for non-compliance, the EHRC do have enforcement powers. And if you do end up at tribunal, this is likely to seriously damage your defence to a claim and potentially land you with up to 25% uplift to compensation for relevant claims. If you've got any questions at all, put them in the comments. I'm happy to answer. I hope you enjoyed the video. Don't forget to subscribe. I'll see you in the next one. Bye.